Thank you very much for coming to AEO Nuts and Bolts today. My name, again, is Larry Lancaster, and my partner, Rick Bandlin. We're going to spend a little time today, depending on what your objective here is, we're going to spend that time introducing you to the concept of administrative enforcement. But if you're someone who's already got a lot of experience, then really our focus for you is to provide you a comparison, a contrast of how two different agencies take the tool of administrative enforcement and apply it. There are some real strengths from each program, some weaknesses that we want to point out as well, and hopefully you'll have an opportunity to consider and have a grab bag. I like that from that program. I like that from that program. I'm going to stay away from the thing he talked about at that point in the presentation. So with that all being said, our outcome objectives for this presentation are that we want to talk about the enforcement options that each agency has and what we do to decide how to enforce. We want to provide a couple of different perspectives from two different agencies on whether or not to actually have an administrative enforcement action occur, how we go about developing our cases, how we calculate the penalties, what needs to happen to convince management that this is a good idea to pursue this option for this particular violator, and then what goes on in the negotiation and settlement process. Each agency has a different set of assumptions coming in, and we want you to hear the different ones and take from that so you can go back to your agency and determine that one approach is the one that you want to pursue. And then finally, we'll finish up with case studies. We have 4 of them for you. They're going to be interesting, from kind of small routine business plans up to kind of an exotic Humboldt County marijuana grow. That's mine at the end, so I'll want you to stay for that. It should be a lot of fun. The first 20-30 slides are going to be text only, so pace yourself, be ready for the text, and then we'll get into the pictures and the really interesting stuff, all right? Okay, with that, I'm going to let Rick take the lead, and I'll be chiming in on the wireless. And if you have questions, we encourage them as we go along.
Okay, first I wanted to say that, can you hear me? The presentation in the back is a little different than what we're going to do here. There were some last-minute changes. I think we added a bit just to make sure we took up the entire time. So in the end, this will all be posted on the CUPA forum website, so everything you will see will be, ultimately you'll be able to download a copy, but the one that in the back of the room is a bit shorter than this one, and it doesn't include all the case studies from Larry. All right, so you've done your inspection or your investigation's over. You have some violations. The first thing you got to do is decide how serious they are. Were they illegal dumping, tampering, or was it just a kind of a labeling violation or some record-keeping violation? So the seriousness of the violations kind of dictates where you go from there. And you can consult your inspection and enforcement plan. If you have a document like that, some people have just a set of policies and procedures. So you take a look at the violations along with some other circumstances, such as is it a repeat offender, is it recalcitrant, always going back to see the same violations over and over again. Depending on how that works out, you consult your inspection protocols, and then you have basically these 5 options: informal enforcement, the administrative enforcement order, which is what we're going to focus on, civil action, criminal action, or permit revocation, or facility closure. So hopefully 99% of the time, informal enforcement gets you to where you want to be and the facility back into compliance. And that's done with your normal inspection and reinspection process, your notice of noncompliance, inspection reports, sometimes that's the same thing, or letters, NOVs, or office hearings if you do that kind of thing. For those times when formal or informal enforcement fails you, or the nature of the violations are serious enough dictates formal enforcement, then you have to go to the next level, and that's formal enforcement. And that's basically something that mandates compliance. It's done either through civil action, criminal action, or administrative action. In each of those, you have penalties, fines, and in the case of criminal, you could have jail time. There's also supplemental environmental projects for, other programs, and I think Larry's got some examples too.
I'd be interested to know how many of you are familiar with SEPs or supplemental environmental projects. It's about a third of you. Those are a creative way of working with the violator to get closer or get to a settlement quicker when they have the option of something just different from handing you a chunk of money as a penalty. You give them the opportunity to do some community good through this creative SEP process. And we'll go into that a little bit more.
So,
is my mic on? Can you hear me? Okay, thank you.
I can hear you from here. So either way, civil, criminal, or administrative, you do have, at the end of it, some kind of enforceable agreement, either in the court of law or through your own agency. So as far as options, like I mentioned, criminal, civil, and administrative. Criminal is usually, first of all, you have to have a violation that lends itself to criminal prosecution. So it's got to be, felony, like 25189A, or I think it's A, illegal disposal. And then you have to have, the resources available to prosecute. Civil is usually, if we have, also, forgot to mention, criminal, in addition to having a violation that is, can be prosecuted criminally, you have to kind of, from your enforcement or from your inspection, be able to identify a person. It's not just that the facility didn't do this or that, but you have to kind of have enough evidence to show that this particular person did that violation. Because otherwise, you can't prosecute criminally without a person. And civil penalties, I think of when I have inspectors that either there was a store over there, and across town we have another store over there. They're finding the same violations. So those tend to go civil. It's usually something that's going to be corporate-wide or company-wide. And those get referred to the DA most likely. And then administrative fines and penalties, that's what we're going to talk about here. Whoa, echo. All right. So like I mentioned, for criminal and civil action, you obviously need an outside prosecuting agency. It could be either district attorney's office, city attorney, or your own county council. And then the final agreement is going to be in a court of law rather than within your own office. And then you also have a much higher burden of proof. So with criminal, I think you have beyond a reasonable doubt. Civil, you have preponderance of the evidence. And then with your own administrative action, you basically just have to prove the violation existed, like a photograph showing whatever the violation is enough to prove that the violation occurred. That's all you have to do. So the resources needed are a lot less. One of the, when administrative or criminal or civil is not needed, then administrative enforcement is often the best alternative. It's generally quicker and requires a lot less resources. Like I mentioned, the burden of proof. One of the biggest advantages over criminal or civil is that you and your agency maintain control over the whole thing. It's not something that gets referred to the outside. So you have total control over how the case works. And in the end, you also have, you get the penalties collected.
The real art of administrative enforcement or deciding whether to go with a district attorney is, am I going to put a bigger stack of resource in this case, or is it really appropriate for this case to only use in-house environmental staff for an administrative case that only has a lower threshold of proof? So really, as a manager, you want to be able to kind of look at the totality of the case, the kind of time that is going to be involved in getting that case resolved, and determine whether really putting that much effort into an attorney, the district attorney's office, is going to pay off with the kind of result that you're looking for. If, in fact, you could do 3 cases of similar type with the same amount of time and resource, then maybe this decision over here at administrative enforcement is going to be the way to go, and you save that district attorney for criminal cases, for other caseload, and then when you do use them, you've got them fully behind you. So it's really an art determining which of those brackets to put the cases in.
Right. And then sometimes it'll also be depending on what kind of evidence you collect. Like I mentioned, there's a lot less evidence requirements when you do administrative processes. You basically just have to get your sample or evidence, legally obtain it with their consent, and you're pretty much good to go. You don't have to deal with a lot of the discovery rules that apply to civil or criminal cases. And then sometimes, like the third bullet says, that's going to be your only option because your DA or your city attorney is kind of overtaxed with other priorities, and they're not available anyway. So sometimes the AEO process is your only process. It's your only choice.
So in Humboldt County, when we're looking at a case, we've got 4 basic choices to choose from, and that is internally with the administrative process to refer to the DA, as we've talked about a couple of times. If there's a business that covers several different jurisdictions, it's multi-county, then that's something we might consider that it wants to be tackled at the state level. An example of that might be the Big Oil and Tire. You may not have heard of that, but they covered several counties in the north, and they were repeat offenders. So it was something where we'd already had judgments against them. They were back to the same old tricks. And quite honestly, we'll get into the dynamics of really small counties and your connectedness to the Board of Supervisors, your local elected officials. It was prudent in our case to turn that over to a more impartial, bigger body, the State Attorney General's office, to prosecute that case, and we got a very favorable judgment as a result of that. And then also other agencies such as Fish and Game, Cal EPA, Fed EPA, when the politics, when the scale of the hazard are such that they really exceed our ability to be expert or to efficiently manage it, we hand it off to another agency. Yeah.
I would like to point out for those who are from Department of Toxic Substances Control, the choices that we make for refer to DA or AG are slightly different, so that we don't get confused. We refer to DA only for criminal cases, not for administrative cases or civil cases. We refer to AG only for civil cases, not for administrative cases. All administrative cases we handle within DTSC with our own attorneys. Now the choice for AG, we make very early on, depending upon the complexity of the case. If we believe that the case is much complex or the penalty amount going to be, I think the cutoff limit that we used to have it still applies is like $75,000 or more, then we have automatically referred to the AG so that we have AG on board early on and work with the AG because we believe the case is going to be eventually referred to for civil complaint.
Perfect. So I hear you saying that every agency, state versus local agencies, as long as you have a clear set of guidelines how to make your decisions on enforcing the case, you can't lose in that situation because clearly you've thought it out and you've prioritized and you have a good result. And that's nice to hear the DTSC has such a tight set of guidelines.
For Ventura County, we primarily do formal enforcement through the AEO process. Like I mentioned earlier, the DA, we do get involved whenever looks like it's going to have criminal or civil action in its future, depending on the violations and circumstances. And then other agency referrals, that could be air pollution or stormwater. And usually that's all coordinated through our environmental crimes task force meetings. We meet monthly, and there's our agency along with the DA, code enforcement, air pollution, and a bunch of others meet and kind of discuss cases that are going on within their realm of regulatory authority. And that's a good way to see what's going on and refer outward. And then they meet with their counterparts in other parts of the state, and then that's how these statewide cases get initiated.
How many of your agencies participate in environmental task force meetings? So again, half maybe. If you're among those who did not raise your hand, we strongly encourage you to try and work with your district attorney, your circuit prosecutor if you're a rural county, and try and get multiple agencies into the room together, because it is synergistic. You get a better result from the group process than you do from individual agencies trying to enforce on what turns out to be the same violator. But when you sit together, you find out that you guys are each pursuing cases individually, and it oftentimes turns out that you've got a big multi-agency case, and you can effect a much more efficient prosecution when you work together.
As far as the agency referrals, I mentioned air pollution, DA. I think Larry's got an example of fish and game. But whenever it's not within your regulatory authority, you refer it out to that agency if it's a better fit, or when you're doing your own inspection. And recently, the second bullet there, transportation, we found some anomalies with a certain transporter who would go to multiple facilities. We called DTSC, and they came out and went to those facilities, collected evidence as far as copies of the manifest, and still they're going to work on that now. I don't know how it's going to get resolved, but that's an example of when you refer to the outside agency, because although you inspect them for their manifest, the transportation that you discovered during that's somebody else's.
And using that fish and game referral, it's kind of not very satisfying actually, but they're the best deal going. When I go out to marijuana grow operations, and we'll show you pictures of that a little bit later, we encounter mountains, little tiny mountains of spent what we call grow medium, and that's what the plants are grown in, and they over time accumulate salts and just become non-optimal for marijuana growth, but they still contain a lot of nutrients in them, and they're something that shouldn't be put out into the environment. Well, as it turns out, they're dumped out the back of the grow houses, and when we get our 40 to 60 inches of rain each year, of course all those nutrients are going to leach straight out of that grow medium and into the closest drainage, and ultimately into the wild and scenic rivers that we have up that way. And it's evidence every fall that we have all this material from careless marijuana growing, and it's killing off the fish in the river. There's a real disconnect between the growers who think they're creating a nice green product and what's happening in the river 5 miles downstream. Very frustrating, and the best opportunity we have when we refer to another agency is to give it to Fish and Game for a 5650 violation, which maxes out at $1,000. Well, that's nothing in the world of marijuana growing. It is an appropriate referral to make, but I'll tell you, we sure wish we had a better, stronger set of regulations that we could impose. None of that stuff is hazardous. That stuff is just something that is affecting the waters of the state of California. 5650, it's a slap on the wrist.
These are legal growers that you're talking about?
Well,
if they're not following that rule, why would they follow the other one?
Well, that's a great point, and they follow the rules because it becomes economically unfeasible not to, and that's part of what I'll be presenting a little bit later. I'll leave you to decide whether, in fact, the fines we can impose really are a disincentive for them, but we'll wait for later in the show. But no, mostly those are illegal grows, although with every illegal grow you have a 215 grow with 100 plants over here, which is the legal part that they claim to be doing. Never mind the 5,000 plants in the shed back, 100 feet away.
Oh. Other times when you'd use an outside agency, even if it's within your realm of regulatory authority, you might not have the expertise, maybe a CalARP site or a APSA site. It's new to you and you still haven't developed the expertise on that. And then with the Crimes Task Force, in addition to referring out, they can also refer up to you. So they may see something during their inspections that warrant an investigation by your department. So it kind of goes both ways with the task force meetings.
In Humboldt County, we don't run cases simultaneously with the DA. It's either our case or it's their case. That's not 100% true, though, because we do have right now a murderer who he was also a grower. So we've got the grower end of the thing, and he's got the DA's got the murder charges on him. So from that standpoint, they will run parallel tracks. But we wouldn't want to even consider handing over our environmental violations, because when you're dealing with charges that serious, any kind of a plea agreement or any kind of a legal proceeding, our charges are going to get thrown out in a heartbeat. So it's much more wise for us to hold those charges and pursue them administratively. There's still a big question as to whether we're going to get satisfaction when the guy is going to be in jail forever. But we can attach to the property once we get the judgment. There are ways to get that money eventually. So we as a general thing, we don't have our cases conjoined with the district attorney's office.
In Ventura County, we deal with the DA's office a lot, and those cases that look like they're going to be criminal or civil, they get first choice at those. But we don't do it concurrently, though, as well. But they're kept involved in the loop through the task force meetings. One caveat there is sometimes it backfires, because a case that may look like it's going to be a civil case, multiple jurisdictions, they may investigate, and that may take a year or 2 or 3, and in the end they decide not to file. So the violator or their respondent is left with kind of the feeling that it's over with, but then we come back and go, should we do it or not? We got to decide. So, and then when we decide to initiate an administrative enforcement order against a site that's kind of been cleared or not by the DA, then it's kind of sticky, and we have to, they have the expectation that they're done and in the clear, but then we come back and get them for fines and penalties. We're almost done with the text. And my wife saw this a few days ago, and she said, that looks so boring. All right. The goals of the AEO are basically to return the facility back into compliance as fast as possible. And that's primarily done with penalties and fines to eliminate any kind of economic benefit that they received through violating the law, punishing the violator, and then deterring future noncompliance. You have to make, when you're working out your penalties, and we'll talk about that a little later, you got to make the cost of the violations or the cost of noncompliance at least more than the benefit to them of noncompliance. They can't make it low. You can't make the fines low enough that it's just the cost of doing business. So in Ventura County, I'll just go over the typical process, how it works for us, and then Larry will kind of do his thing. But it starts out with our inspectors. They're out in the field. They'll either call or come back to the office, say they found a Class 1 violation, or they're having trouble with somebody who's, always just ignoring them, or repetitive violations. So if they're on the field, sometimes they'll ask for direction, and we'll help them out with what kind of evidence to collect, kind of statements to get. And then when they come back to the office, that's when we kind of go over the case, and they work on this document that we call a statement of facts, and that's what we would refer to the DA's office if we choose that route. But it includes, and this is the case development part, all the inspection reports, correspondence, sampling results, all evidence collected, statements, drawings, parcel information, and it's all kind of put in exhibits. It's kind of a thick document. And usually a narrative goes along with it. This is the most time-consuming part, and we'll talk about roadblocks to AEOs later, but this, for us, it's kind of time-consuming. We'd like to streamline it, but it's, excuse me, when you're writing it, your statement of facts, you kind of have to have, as your audience, somebody that may not be familiar with how an underground leak detection system works, so you kind of have to go into excruciating detail, because the person that's going to read it might not, whether it be the DA or the administrative law judge, might not have the expertise. So you have to make these detailed narratives, which they generally, they don't like. We try to go off of our existing ones from similar cases, so they have some kind of template, but still, it takes a lot of time. And then we review the case with the CUPA manager. It's all put together. We kind of tell him what we got. He gets the ultimate say on where we go from there, whether we refer it to the district attorney's office if it looks like criminal, or if it looks like multiple sites or jurisdictions. And then if not, we decide on an AEO. And then depending on how cooperative is the violator, we can either go with the show cause, which is what we primarily do, or something like a unilateral order. If we feel from our inspections or history with this person that they're just not going to play ball, they're just going to snub you no matter what, we could just go straight to a unilateral order, especially if you think negotiations aren't going to happen, they're not going to be cooperative. Here's an example of sort of a show cause letter. It's also known as a notification of potential filing. It lists all, the who, what, when, where, and why of what we saw, what the violations were. Usually it has, our authority for doing this, copies of inspection reports, but basically it's our kind of send out to them saying, we're thinking of filing against you, and near the bottom there it's kind of but we'd like to extend to you the opportunity to meet with us to resolve this. And this is kind of just a diagram of how the whole thing works. Basically, the show cause letter goes out. They either are going to cooperate or not. If they don't, we can issue an AEO. Primarily, that's the unilateral order, which is basically, this is your fine, pay it, or else. And the or else is they request a hearing. But let's say they settle, or they want to settle, then we set up settlement discussions. We'll set up a meeting, which we call the show cause meeting. And then if everything goes well there, we reach an agreement, and that goes into the consent order. If not, it's back to the unilateral order. And then in the end, we have this consent order where it'll have penalties, and it'll go to the operator. They'll sign it, and then we'll sign it and verify. Back to the general process, we do, prior to our meeting, we do what we call the Tribunal. It's just me and another supervisor and one of our lead hazardous waste guys. So we get together, kind of go over the violations using the penalty matrix, which we'll see in a couple more slides, and you're probably familiar with it if you've done AEOs. But we kind of go over each violation and go on the chart where you think it would fairly end up, depending on the extent of well, we'll get to that. And then we issue the letter, and then we have the show cause meeting if they show up, and then that's where we kind of lay out the case. We have that statement of facts, which I mentioned, which has all these exhibits. It's got, their signature on things, all our evidence. Basically, we lay it out in front of them, showing we got you. This is everything that we would present to the DA's office. So we make it seem like pretty much open and shut, so they'll want to settle. Generally, on almost all of them up till recently, they haven't brought any kind of legal counsel. And we don't either. If when we make the phone call, we ask them, is it just going to be you guys, or are you going to bring a lawyer? And if they do, then we bring our own counsel, county counsel. I've found out just through our own workings that it goes a lot smoother without lawyers involved. Any lawyers in here? Okay. They tend to cloud things a bit. It's kind of interesting to watch because they do their lawyer thing, but in the end, it kind of just gets in the way because they kind of have to show that they have some value to their client by negotiating, and in the end, it's a lot like buying a car. You kind of have a lot of back and forth in the settlement, whereas when they're not there, it's a lot more, we have a number already in our heads, and then we throw it out to them and then kind of look at them to see if they blink, and then it goes pretty well from then. But otherwise, when they're lawyers there, it's kind of a back and forth. It's like, oh, I got to go talk to my sales manager, and they have to kind of do that. We understand it's part of the process. They have to show that, they got hired. The lawyer has to show that they've kind of did something to reduce their penalties or fines. And then finally, the consent order, if everything works out, we issue a consent order. And that lists all the violations, any kind of penalties or supplemental environmental projects, and then the cost recovery. And then the cost recovery is something you can only do through the consent order. You could try to do it in a unilateral order, but if it gets to an ALJ, they'll throw that part out. But when you have a consent order and they consent to it, you can include those. And that's what we've tried to do. So we send out the consent order, they sign it, send in the penalties hopefully, and then we wait for the check to clear, and then we'll go and do whatever kind of follow-up. If there's SEPs, we'll have to go verify, if they have some kind of timeline to them that was done. Yeah, question.
I think that's what you said, an ALJ will throw out one part of the consent.
The cost recovery part, when you put in your time, you kind of combine all your time that you spent on this case, which could be hundreds of hours, you can't charge for that. You can't legally, I guess.
If it went through the administrative law.
We had that part thrown out of our ALJ case. It was news to us too. We didn't know.
Well, I'll give a shout out to our county council. They caught that for us. We just recently went to the ALJ and they pulled that from our case. So we were pleased not to have to sit in front of the ALJ and have him say, why are you trying to get agency costs? That's not part of this process. So if your county council is working in sync with you, they'll catch that kind of stuff. It's a natural error that any staff can make, and we just want to count on them to parse out the legal code and those fine points. So in Humboldt County, the field...
Is it just for a unilateral order versus a consent order, or is it for any order?
Well, with the consent order, you can put in your, because they're consenting. They're saying, yeah, that's okay. Well, you can throw that in.
When the administrative law judge is hearing a case, that would be the instance. Otherwise, as Rick said, they're agreeing to this, and we're saying part of the agreement is we want the remuneration for the time spent. In our county, yeah.
Just so I understand it, so if they dispute the case or the situation and consent to the order, then it goes into a unilateral.
They actually file a notice of defense. That's a document you send to them, and if that's their way of saying, I don't agree to this settlement, we're at a point where we need to put ourselves in front of an administrative law judge, who then comes from a regional office, from the Office of Administrative Hearings, and sets up court wherever it's agreeable to have court. In our case, it's at our office. I don't know when you do
Yeah,
it.
they're in our office.
Yeah. And so when they file a notice of defense, okay, then that's where we're going. It's an unequivocal statement that we're going in front of the administrative law judge.
But, sorry to interrupt. That is an important consideration, though, when you're doing penalty calculations, and we'll talk about that also later, but if you had a lot of staff time that ended up being a big dollar amount, and they don't consent, then when you issue the unilateral order, it could be less than you were hoping to get through a consent. So you have to kind of take that into consideration when you're planning out your penalties. You kind of have to gauge them to see if they're going to want to negotiate, and something you have to keep in mind, because if they're too high, they can get a better deal if they just do a unilateral order. So those cost recovery, can be, if you spend a lot of time on it, it can be a problem, because, yeah.
GTSC does slightly different. We do not include admin cost as an add-on cost to the penalty. What we do is we look at each violation, and based upon the penalty matrix that we have in 3022, we see where do they fall, and then calculate penalty from that point onward. When we have a number that we have already figured out for the penalty matrix, then from that we figure out how much is our admin cost, because we already have everything tracked, all the hours spent on the case. And then, for example, if to the penalty matrix we come up with $100,000 penalty, and then we look at how much our staff time or attorney time is engaged in, say it's like $10,000. Then we say, okay, $90,000 is the penalty amount and $10,000 is the admin cost. But we do that afterwards, not before. We do not add on, we do not calculate admin costs early on, only at the tail end. And that is subtracted from the penalty that we calculate. So that's the difference.
So one way of looking at the penalty matrix is this is the maximum amount we're going to get, and we can come in afterward and then from that amount give to staff.
What are the other costs?
Yeah, what the costs were. Thank you. So that's good to know from DTSC. Thank you.
There's, if you're interested, in entire presentations just on penalty calculations, and one of them is kind of working backwards like that.
Terrific. Okay, in our county, the inspector who goes out and does the investigation has the eyes on the ground, and they're the ones that have the best sense for if this would meet the test of an administrative enforcement hearing or other referral. And so they basically make the pitch to the program manager who's below supervisor and to myself, and we're convinced, and we say go ahead and complete a preliminary case assessment, a PCA in our parlance, which includes the things that you see bulleted there: chronology of events, at least a rudimentary penalty calculation, if not a very comprehensive one, a record of what correspondences occurred.
Did you want to get up here?
Oh, yeah. How do I do that? I can change my page on my little tough book all day and you won't see it. Photos, parcel maps, information about property ownership, the draft show cause letter or a quick settlement document, and we'll talk a little bit about that. And all of that's bundled with a memo to our director, who then evaluates it and says, yes, this looks to be appropriate. We're on board. I will be forwarding it to the people above me. And again, referring to our small county, there's never more than about three. What's the movie, 7 degrees of separation? You're never more than about 3 degrees of separation from a local elected official. So word gets up to them quickly, and that has an impact as it comes back down to us. So in our county, you have to really be able to bundle things and sell the product very well so that everybody's on board and nobody is surprised. They do not take kindly to surprises. Once it's approved by the director, as I say, they will submit to county council for review and then up the chain of our department. And everybody has to be on board. Something as small as a small AEO will be reviewed by our department head, which is 800 employees in our county, and that's big for us. I don't know how that compares to where you work. But county council will, as Rick said, attend those meetings where the respondent has indicated that they are going to bring an attorney. And in the case of the marijuana grow cases, they always bring an attorney because they're some of the best paid attorneys around. And so they're always there, and they're very creative in finding new ways to try and undermine what we've laid out in front of them. So the tighter the case, the fewer whispering into ears of people who are in the county and might be in the decision-making process, the better the result we have.
If you anticipate that you're going to have to use county council, do you incorporate those costs into your penalties?
We do take, the question was, do we incorporate county council hours into our cost? Yes, when it's not to the ALJ stage where we just talked about. Yeah, when it's a consent order, we will ask for their hours as well. Interestingly, they bill at a lower rate than we do, so I like that thought. I'm worth more than a lawyer. Our expedited process or quick settlement, it's had mixed reviews, and different jurisdictions may be able to report different results than we have. We've found that with county council reviewing everything that we do, the amount of work involved in a quick settlement equals about what a standard administrative enforcement process would involve. Our theory is that if we keep doing them, eventually we'll get to a point where we see the return on all that effort, that our documents will stand up to scrutiny each time and won't have to be modified by county council. But we do find that they find new things, and as we have new staff come on, their points of emphasis are different, and we have to modify the documents almost as much as we do with a normal AEO. So the jury's still out for us in terms of the quick settlement. But what we do is we send them a settlement letter and a cover letter. We present them two options: pay this, or let's go to a hearing. And we hope by doing that we're saving time for them and we're saving time for ourselves. Penalties, we're now switching into that penalty matrix discussion. And penalties have in code several different factors that have to be considered that will either enhance or reduce the value of the penalties. Those things are listed here. The degree of harm affects how much you ultimately are going to impose in the form of a penalty, as does deviation from the regulation. The economic benefit, how uneven was the playing field for this business or this grow operation? How much did they benefit by skirting the rules and the regulations? And then finally, the ability for them to pay. If they are broke, it's going to be hard to compel an administrative law judge to try and squeeze blood from a turnip. So those factors, again, as part of the art and science of presenting these cases, you have to weigh these things and make them palatable for the respondent, adequately punitive to make other businesses or this operator not want to repeat the behavior, and reflective of their ability to actually pay a penalty. It's not worth anything if it's just a piece of paper saying you owe us $1 million.
What kind of research do you do to evaluate that ability to pay?
Well, we're usually in the reactive mode in our county. When we come to a settlement meeting, and again, because the bulk of my experiences with growers, well, they come in shoddy clothes and they plead poverty, and they're very good at it. I would suggest that they're counseled on how to plead poverty. Our response is you need to get a certified public accountant to do a thorough review of all of your assets and present that document to us. And we've gotten complete forms that lay it out pretty well, and we're compelled to agree that they have a difficulty paying the higher penalties we might be considering. But on the other hand, we've had CPAs sign documents that are, well, I couldn't find this, I didn't know what that was, but here's my best guess. And so we discounted that document. The ALJ, should it go to that level, is a human being, and they sometimes are compelled by less than stellar documents, and other times they throw it out outright. ALJs are they're not experts in environmental law, and as Rick said, you have to bring them along. The better job you do at bringing them to understand what the issue is, what the regulations state, the better chance you have of them supporting you fully as you go through that part of the process.
I would like to elaborate on her question on inability to pay. Actually, we call it inability to pay rather than ability to pay. When they tell us that they don't have the ability to pay, then we go into inability to pay mode. That means that we offer them that if, depending upon our assessment of their financial, whatever they have, assets and all, if they really truly have inability to pay, then our penalty will be set based upon that. It may be zero penalty or whatever ability they might have. At that time, we have a set process and set number of documents that they need to submit to DTSC, and a few of them are like 3 years of their tax returns. Their all the assets that they have, if it's not incorporated organization, then their personal assets, their homes, the renters, all that information, plus their business plan. Well, how much money did they make this year? How much money did they make last year? Or not make that money? All those documents then are sent directly to our auditors. Our staff people, or the inspectors who are working on the case, are not supposed to look at those documents at all. So they only move from the facility, if we have an attorney or AG, to the AG or attorney to our auditors. Our auditors look at all the books. If they need additional information, they make a request. If not, then they make an evaluation. Based upon their evaluation, they set how much penalty that they can pay upfront and how much penalty can they pay over like a 3 to 5 years period of time. So we take that recommendation and we then put on the table for the facility. This is what our auditors have come up with, and this is a plan if you are willing to take this plan. If not, then we go to civil or admin.
Excellent. It sounds like a bigger agency like yours can really devote some resources to evaluating what money or economic status the respondent has. So again, I got to give 2 thumbs up to DTSC. Our little county doesn't have that luxury, and so you might yourself be asking, okay, well, what kind of county or what kind of agency am I in? Do I have the kind of resource that's being described there? Or do we have to come up with some way to cope with someone claiming I don't have the ability to pay in a small county where we don't have the money to hire a CPA or an accounting department that can go over that kind of information? And that's the purpose of this whole talk today, is to say there's different kinds of agencies. The careful planning will give you the best results. From here.
Just to expand also the question you had about ability to pay or inability, there are some couple of documents at the end here from Cali, PA about there's frequently asked questions and also just the AEO guidance document, and they get into details about forensic accountants and what kind of information to request. We don't have an auditor that I know of, but we did request it, and they just said, and that's going to be one of the cases I'll show you. Luckily, they didn't give us anything because we wouldn't know what to do with it. We probably could have figured it out. But they, that document lists what to request, such as what you're saying, tax records and other information or documents that show their net worth, their what they owe and what they have as assets. So we briefly talked about this document earlier. This is one of the penalty matrices. There's one for each of the CUPA programs, and the minimum and maximum, they're the numbers. They're taken directly from either a statute or regulations. This one's for hazardous waste, and like I said, there's one for each. So on the left, and Larry talked about the extent of deviation. You have that on the left. It's broken down into major, moderate, and minimal, sorry. And then on the top is the actual or potential harm. So basically you look at this chart, look at your violations and the other circumstances and find out where it falls within here. So that top portion, the degree of harm, that is broken down in 3 categories. In that, these are some examples of what major harm would be. And it doesn't have to be actual harm. It can be what could have happened, such as injuries, pollution, just contamination of creeks and rivers and streams, or even wildlife problems. Or at the bottom there, microbial damage, such as here, Larry's example where they had an increased BOD demand from fertilizers and other things ending up in the streams. Deviation, that's on the left-hand side of that matrix, and that's basically how much from that law did they deviate. Was it major? Did they just completely ignore it? Or was it moderate? They kind of ignored it, but it somehow worked a little bit anyway? Or was it minimal where the law was violated, but the overall impact or effect was minimal? It's kind of no harm, no foul. And then these are some considerations to take in addition to those on the matrices. But you do get your initial penalty from the matrix, and then these are other things to take into consideration.
Yeah, for us, has the business been compliant historically? Have they cooperated through the whole incident, through the enforcement process? And again, the political outfall from this event in a small county can be significant. So we have to take that into account. It doesn't drive our decisions, but it has to be a factor. And you can ask yourself, is that a factor in our decisions? If not, that's probably a good thing.
Yeah, we have a bigger county, not as big as some of your counties. Ours is about 700,000 or 800,000. Larry, I think 150. So we don't have much political pressures on us. It's big enough that although it happens, like the degrees of separation are increased. There's at least 5 or 6 and not 3. But one of the big things we take into consideration is the consistency. We just want to make sure that a similar case, like raised probes, for example, if we had settled on a penalty of $5,000 and they had similar circumstances, similar violations, we're roughly in the same ballpark. We're not, for similar violations, charging 2 or 3 times more. And then we also take the compliance history of the operator into account, and then, like I mentioned before, the cost recovery, when and when not to include that, depending on how much it works out to be. So once you have the kind of the ballpark figure worked out through the matrix and the other circumstances, then there's adjustments you can make, downward and upward up to 100%. If the violation was, completely out of their control, you could downwardly adjust it 100%. Or vice versa, if they completely disregarded the law, you could go upwards to 100%, keeping in mind that you can't exceed the maximum listed in the law. So if it's a $5,000 maximum penalty and you settled on 3 but you wanted to double it, you can't go to 6, you have to go no more than 5.
Selling your case to management, again, back to that recurring theme of small county, got to have everybody on board. You need to be prepared to lay out the history of the case, why you've gotten to the point where you feel you need to use an administrative enforcement order. You need to have the penalties really clearly laid out for a reluctant management. So here's the maximum penalties we're looking at. Here's our target settlement that we're looking at is 15%, which is not an unrealistic goal, at least in our county, although there are times when 35, 40% is really appropriate for the deterrent factor. And other times, maybe a smaller one. When you look at the totality of the situation, a smaller settlement would be appropriate. And the management, in our case, is going to want to know, how did you get to this point? What events have transpired? What have you tried to do to get this person into compliance and to get them to resolve this enforcement case? All those questions are asked point blank, and we have to be able to satisfy. Otherwise, we'll get the thumbs down on pursuing this case. So we really do take a lot of time to prepare that information and obviously be able to represent how much money the agency has put into this effort and to characterize how the respondent or the offender has participated in or not participated in the process thus far. And those are the managing issues that can be a reality if your agency has a reluctance.
Question about your layers of management. For that type of decision, does it rise to the agency director, or does it actually go to your elected official for that?
The question is, what level do these issues rise to? Is it up to department heads, or is it all the way up to the elected officials? If the system as it's set up is operating correctly, right now it goes to the department heads for review. If we're getting emails or phone calls from locally elected officials, then we feel that the process is broken down somewhat. Those people should be being informed by department heads, but they shouldn't be hearing from the respondent, or they should never be surprised by the respondent. They should be fully informed and recognize that the department's got it covered, we're pursuing appropriate enforcement, and go from there. And I'd like to say that happens 100%. It happens a majority and maybe mostly. Okay, roadblocks. Humboldt County, again, small county, there's fewer of us, so each decision takes on a bigger proportion. If the business is suffering economically, and again, that goes to ability to pay, it's going to be harder to get them to agree to a settlement. It may also play into the kinds of steps they can take to correct the environmental harm. It just depends. If they're suffering, it's going to be a harder slog. The process is slow. It takes a lot of time, and in our agency, there's review at each level and then checking back with people. So the paper moves an awful lot before it actually gets resolved. And this is a kind of a sad bullet point. This fourth one, I talked about our growers. They have actually, their most effective response lately has been just don't pick up the certified letter. And it really stops our process. We don't have, as Ventura, I believe, does, the ability to go right after them and have law enforcement go to them. We can do deputy delivery, but they have lately forestalled us from moving forward, and I'm sure it's on advice of counsel. Don't pick up the mail. Don't come out and open the door. Don't show yourself at all, and it will become a molasses in the works. And that's the challenge that we're facing now. So uncooperative respondent is definitely an impediment to progress on AEOs.
Can you just serve in person?
Well, the most recent example we have, we tried to serve on a guy who has a 6-foot fence and 2 pit bulls going after it, and a note on his door that says, "Don't try and serve me anything." Yeah, oh yeah, yeah. So it's not subtle, but it's at the moment that's the challenge that we're facing. How do we get around this strategy?
For us in Ventura County, staff time is probably the biggest roadblock. We don't have any of those, the Humboldt County issues, luckily. We get actually the opposite, not problems, anything like that. We actually, our management wants more. They want us to do more of these. And it does take a lot of staff time. And we'd like to streamline it. I know there's some examples where, and there's other discussions or presentations here. I know San Diego kind of doesn't do the AEO as much. They do something called cease and desist orders, where they've presented that and have had a lot of success with it. Or you can just go and do facility closures, revoke permits. But for us, staff time is the biggest time-consuming thing, because we have those large packets of narratives and exhibits, and they take a lot of time to develop. It would be nice to have a streamlined approach. I think Sacramento also does a kind of an expedited process where they just send out some letters, here's how much you pay, send it back.
And the cease and desist is faster?
Yeah, I think they...
Less comprehensive, less people,
Less paperwork, less steps. And there is a presentation on the CUPA Farm Board website from 2 or 3 years ago, presented by San Diego County. And then, like I mentioned before, the DA can complicate things we had 2 recently where we decided to go forward anyway with an AEO because we had this righteous case, and they just decided, it didn't work out for them, but we took it on anyway 2 or 3 years later, and they were kind of resistant, but it all worked out. Okay. Yeah, I'll try. We're done with text. I think we can move on to some pictures now. You guys all did really good. I'm sorry for the text. I'm just going to do 3 brief ones, and they're all a little different. I'm presenting them for a little different reason. This first one is because it resulted in an ALJ hearing, even though it was just a slam dunk. It was typical tampering where, and you can see in the photo, the sensor was wrapped around the conduit, so it was obviously intentional. And then below, which you can't see out of the frame of the camera, is some liquid in the under dispenser containment. So this was just, open and shut. Should have been settled pretty quickly. But it resulted in going to an ALJ, and here's just kind of a timeline to show you all these processes that go on and how these things can just drag on. So in May, we saw the violations. We sent out the show cause letter in August, and then we met with them in October, and we thought everything went great. They agreed. We first had to determine if they were the right people. They're kind of, some of these corporations, they have little shells here and there, and they move them around. So we issued the consent order because we thought everything went well. They agreed, but then nothing. They didn't send back the money. They didn't sign the order. So phone calls with them for 4 or 5 months on, oh, he's out of the country, he's out of town, we're going to sell, things went kind of dragged on, and maybe we probably dragged them on a little too long as well. But they seemed to be, they were cooperative up to that point, but they just kind of had a lot of excuses. So finally, we just issued a unilateral order because we figured, okay, they're really not going to pay. So, and they responded with the notice of defense. So we had to request the administrative law judge through the Office of Administrative Hearings, and we got a date, and we finally settled on August. So we're already over a year into it. And then a couple weeks before the hearing, the respondent's legal counsel requested a continuance because he had to go to the dentist or something. So we weren't able to get another date until that everybody could agree on until December. So now we're like a year and a half into it. And then 2 more months later, we got the decision. She decided in our favor. And the hearing itself was maybe 6 hours of listening to a lawyer do his lawyer thing. And then finally, we adopted the decision, which is part of the process, and then sent it back out to them. They didn't do anything. They kind of are, they have problems with lots of other agencies and other jurisdictions. So we, as a formality, we issued a demand letter in June to show you, hello, we're reminding you that you owe us some money. And they didn't do anything, so we referred to those documents that I'll show you in the back here, and it says what to do if they don't pay. So we converted it to that decision to a judgment, and that's done through our Superior Court, and that's through County Council. So now they're charging us money too. They were through, actually once it goes to the ALJ, you're going to be paying your County Council for all that time as well. They're really helpful, but then in the end they send you a bill. So the last 2 bullets there are done entirely by County Council. Then what they do is record an abstract of judgment against this person. This person didn't have any property, real property in our county anymore. They had sold it since. A year into it, they had already sold the property. So they didn't have any tangible assets that we could lien, but this aspect or abstract of judgment kind of records something like a lien against this person. So was it worth it? Well, we probably spent hundreds of personnel hours on this and haven't received a dime and never will. We're in line with, other creditors, and I think this person's in trouble for not paying his employees, not paying taxes through BOE, lots of other things. So, but some of the things we did learn is just that you have to, like I mentioned before, get that case really tight, because they're just going to pick at any little thing when they're going through your documents, anything to create confusion. And in this case, they had submitted some UST paperwork that showed a different name of the operator. It was the same company, but his lawyer was just trying to reach at anything. So he was using that as like, oh, they don't even know who they're going after here. They got this person here on this document and this person on another. And you know how it works. We get hundreds of these documents in, and sometimes there's a little difference in them. But he grabbed on that, and it could have been any other thing. So other options could have been, like I talked about, just revoking their permit. You still have to go through a process for that too, but it's a lot shorter. And in the end, if we would have known this was going to happen, we could have done that. Or red tagging, and that's also a process, but it's a lot quicker. I think it's 5 days. And that can get their attention. Yeah.
Can you simultaneously start the revocation of the permit and the enforcement, so that so they're more motivated to comply?
I don't think anything would prohibit that. They could be done concurrently.
We red tag and start the AEO. Usually the red tag's resolved before the AEO gets rolling, but we'll use those one after the other to try and get that point made that you can't do that.
And now you're more inclined to do that?
Well, for us, AEO has always been separate because it's something you can do immediately. If it's an imminent threat, then you can tag them right now. If it's something you can give them 7 days, that's, for us, that's completely aside from the AEO process. It's,
Yeah.
I'm actually with San Diego County, and I wanted to make a correction. The cease and desist that you were referring to basically works for the USD program. Whereas with our hazardous waste or hazardous materials, we do have AEOs, and just in the last year, we had about 40 of them. So I just wanted to make a correction.
Thank you for that. The next case is, sure, sorry.
So that when they, after you gave them the violation notice and you told them they had to put the sensor back, did they make the correction, or was this whole time frame?
Oh, no, that's immediately corrected.
It's immediately corrected. So then, how would you red tag them for that?
Well, it wouldn't be an immediate hazard. It would be some of the other, you can do red tagging for, in addition to immediate hazard, just kind of non-compliance. But that is done through a process that takes 5 or 7 days.
you can write it up immediately in the field inspection report and start the process that way. And if they're as reluctant to cooperate, they may use that 5 days and all of a sudden they've got a red tag.
All right. The second one is a little different because it's not an underground tank. Most of ours, actually 60 or 70% are probably underground tanks. This one was just a false statement. And it's started out as just a typical inspection. This is a car dealership. And this is the hazardous waste storage area, and it's just a little sloppy, no big deal. You know, some filters on the ground, some used oil in this secondary containment area. So it just goes down as a regular violation. This is a copy of our inspection report. The violation goes down under spillage, which is failure to minimize. And then this is a document that we use for the operator certified compliance. This is our certificate of compliance, which they send back, and then we use this to clear out violations. This is when the violations weren't something that would warrant a reinspection. We kind of do this honor system where they say, yeah, we fixed everything. I'm signing it, certifying that I did it on these dates. So the sales manager or whatever, service manager did that, and he signed on the bottom there saying he cleaned up this particular violation. And then even that it's the honor system, we still pick about 1 or 2, each inspector picks 1 or 2 of these a month to go out and verify. So in this case, the inspector went back and the violation was still the same. They hadn't corrected it. So they obviously had lied or made a false statement, which was on their form. So we just figured we should at least set an example to keep this honor system going. We need to kind of make an example of them and show them that you got to actually comply if you're going to submit this compliance certification.
Excuse me, so you're not obligated to go verify for every case?
Every violation?
Well, when they say they've corrected on such and such date, you kind of spot check them.
Right. We don't go back on every single.
Kind of wanted to do that.
Isn't it only on minor violations that you can do the certificate?
Right. Yeah.
So then if you have class 2 or class 1 certificate,
Correct. Good point.
Thanks, okay, that was where I was confused.
So in this case, it was a minor violation, and we went back, and she found the same thing. So we had some costs, and plus a penalty. It came out to about $10,000, and they were really compliant after this, and really cooperative. So we gave them a $5,000 credit if they were to complete California Compliance School, a SEP. So they did that, and that we just built that into the consent order. Here's another tampering. Like I said, we do a lot of these tank things. This one was pretty obvious. This is an annular sensor, so it was only, when they pulled it out, the inspector could obviously tell seemed a bit odd that it was only 18 inches long. That's probably a 10,000. It's probably a 10-foot tank. So that wasn't even near the bottom of the tank. It wasn't even on the top of the tank. So this is just an example of a document that we would put in our statement of facts to show some supporting documentation showing where it was supposed to be. In this case, it was a set of approved plans that showed the monitor system, the location of that sensor. So it's tampering, obviously, because it was intentional, but this brings up an interesting point about what other violations that it could also be. So in addition to tampering, it's 3 other violations. It can be failure to maintain the UST permit to operate, because each of our permits describe how they're going to do continuous monitoring. It's also a failure to position the sensors for earliest leak detection, and it's also, in most cases, because it's the manufacturers write it in, it's also a failure to operate and maintain the sensors according to the manufacturer's instructions. So each of those can be its own violation. So we go about this penalty matrix, and in this case it was a major because it was obviously intentional, and moderate, or major, actually middle of the road major, because we were left with a tank that wasn't being monitored at all, and it was in a sensitive area where there's groundwater right nearby. But the point I wanted to make about this is when you get all these together, each of these things, you end up with a lot of money for just the same thing. And that was one of what the, this is from the ALJ excerpt from her decision on another case, because his lawyer contended that this is all just piling on. It's the same thing. You can't do that. You can't charge them 4 times for the same violation. But in her decision, she basically said, yes, you can. Each of those violations is separate and can be assessed the entire amount, even if it's based on the same facts. Yeah.
Well, actually, the way we do it at DTSC is that for any violation that continues to be a non-compliant, we assess multi-day penalties, which is 2% each day of non-compliance. For every 50 days, the penalty doubles. And we tell the facility that we would be charging multi-day penalties. The only time we do not charge multi-day penalty is the time that we have given them to come into compliance. For example, for a tank assessment, we say, okay, you need to do this tank assessment within 90 days. So we do not charge penalty for those 90 days. And if they still are not in compliance, then we start charging for every day 2%. And we bring it to their attention up front so that they understand how multi-day penalty will be charged. And in many of my cases, the multi-day penalty is so much that it runs into hundreds and thousands, if not millions of dollars. And that is a deterrent for a facility to not be in compliance. So that works for us. And we do multi-day penalties of each and every case, for each and every violation.
Yeah, we do as well multi-day penalties. They're a lot harder to prove. Sometimes it's not bad. You have really good evidence, like you have the alarm went off on certain date, you were there 10 days later, and you saw the same condition. You kind of have to infer that the same condition existed from point A to point B. And that's something to take into consideration because you can charge for that. But then if you go before an ALJ, you have to be able to prove that. And then it depends. You have to kind of decide if you want to spend the extra time and resources to prove something like that, or just call it one day and then make it simple. Here's some additional just guidance documents that I referred to earlier. We use them often to just go over some of the details about what happens if they do this or don't do that. And then, like I mentioned also, there's lots of calculation or other presentations available here at the CUPA Forum website. Whole presentations on penalty calculations, how your DA can help you with cases, additional case studies, and also settlement discussions.
Can you go back one, please? I just want to see what that second document was. Slide before. Frequently asked questions.
Yeah, these are on the UPA page, the Unified Program page of Cali, PA. I think you're in a different part here.